16th, 2022, the Housing Board of Appeals meeting. We'll call it to order. It's shortly after 9. So first we will do roll call. So we want to start over here. Charlie, would you like to start?
Here.
Can you please say your first and last name?
Oh, Charlie Graff
Thank you.
is here.
Tammy Evansberger.
Charlene Nicoletto.
Paul Dutterwick.
Don Hanson.
Okay, thank you. So, looks like we're doing nominations for chair, vice chair, and secretary again. So, do we have any nominations for chair?
Nominate you.
Sorry.
I feel snowballed here. Okay. So, Charlie Graff nominates Charlene Nicoletto. Are there a second?
Yes.
Okay. Don second. All in favor?
Aye.
All opposed? Okay. All in favor, Charlene Nicoletto for chair. So now we'll be looking for vice chair. Do we have any nominations for vice chair?
I'd nominate Charlie Graff.
Tammy nominates Charlie Graff. A second? Do you have a second?
Second.
Okay. All in favor of Charlie Graff for vice?
Aye.
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 All opposed? Okay. Charlie Graff will be the vice chair. And for secretary, do we have a nomination for secretary?
Bob Kronovich.
Okay, we have Bob Kronovich nominated as secretary. Do we have a second?
Second.
And all in favor? Aye.
Aye.
Any opposed? Okay. So we have Bob Kronovich as secretary. So is it okay that someone continues in the same position for several terms? Okay. Tried to get us out of it, but that didn't work. Okay, let me see. So approve the minutes from the December 16th, 2021 meeting. Was that? Sorry, go ahead. Is that Charlie makes a motion to approve? Bob did? Okay.
I'll do Charlie will second.
Okay, all in favor to approve the minutes from December 16th? Say aye. Any opposed? Okay. And so now, number 4 on our list, adopting a scheduled day of each month for meetings and hearings. So maybe we could open this up to discussion. I think in the past we had been meeting, it was later in the day on Wednesday. Does anyone have any preference, day, time?
Well, personally, for me, Wednesdays work best in my schedule.
Yeah, same here.
Okay.
I don't remember what days the planning commission meets. Wednesdays.
What time do they meet? 4 p.m. 4 p.m.
On Wednesdays?
Every week?
No, monthly.
Okay. Yeah, what, is it, are they the third Wednesday? Or is it the second?
Yes, because their next one's February 2nd.
Okay.
So just,
So you could pick,
you can pick the other 3 weeks.
yeah. So has anybody got a preference, second, third? The 4th is neighborhood improvement on Wednesday, so I would say second or third. So is there anybody else in here on the second and third on the council chambers?
VBA is at 1 p.m.
I could do either, but I do have another meeting at 5 on the 3rd, so the 2nd would work better for my schedule.
Okay. Okay.
Wednesday of the month. Second Wednesday of the month.
So second Wednesday of the month, we'll have our meetings. We had been going with 4 o'clock. Does that work okay?
Yeah, that's good.
Okay.
And keep in mind that if we have nothing for an agenda, no appeals, and Rich or I have nothing to bring to you, we'll send an email out saying, we have nothing for this month unless you guys needed to meet or something, we wouldn't hold one.
Okay.
So that'll help. Perfect.
Planning commission does the same.
Okay. Do we need to insert any information? I think we talked about it by email, that we were going to move some of these documents to digital. Do we need to talk about that?
Not yet.
Okay,
Yep,
okay.
Not yet.
Okay,
So if you can get a motion then to make the second Wednesday of each month at 4
sure,
p.m.
sure. Okay, can I have a motion to make the Housing Board of Appeals meeting the second Wednesday at 4 p.m.?
So moved.
Okay.
Second.
And all in favor? Aye. Any opposed? Okay. So we will begin to meet, if we have meeting topics and agendas, the second Wednesday at 4 p.m. And number 5 on our agenda, if we are ready for our training session with Doug Herman of Lynch Dallas.
Okay. Well, good morning, everyone. Doug Herman with Lynch Dallas. A little bit about me. I've been with Lynch Dallas for just over a year. I've been an attorney for 27-ish years, I guess. I was a lawyer for 12 years in private practice, did a little city attorney work. Then I was a city manager for 16 years while also a city attorney. So I've kind of gotten away from the policy side back to the law side here in the last year or so, and probably spent 85% of my time working with cities, more headed northeast Iowa than southeast Iowa, but of course our firm represents, I think we're somewhere in the 40-some cities as city attorney now, so there's plenty of city work to be done, and that is my focus. Historically, where I worked as a city manager, we didn't have a lot of the codes the city of Clinton has. So my background doesn't include a significant amount of work with Iowa Property Maintenance Code, building codes, et cetera. We had dangerous buildings, of course, nuisances, things of that nature. My role in Clinton over the last number of months, working with Tammy and Lisa and Rich quite a bit with your codes, so I'm getting more and more up to speed. I will say at the presentation today, the good and the bad of the presentation today is that I didn't really get guidance from staff on exactly what they wanted me to tell you, which I think is good. So this is a totally unbiased approach. However, because of my background versus their background in dealing with this on a regular basis, I will ask them to jump in if they hear me say something that they think requires further clarification or direction. And I know at the end of we have questions answer session at the end. Obviously, throughout this, at any time, questions and answers are more than appropriate. So, and I don't know where I ended up. I think I've got 40, 45 slides. We aren't going to dwell on some of them very long, but you guys can all see one of the screens somewhere, right? Okay. So there's a lot of codes involved for the city, and kind of what's your role in this process and certain procedures will kind of be our 3 focuses. I'd never met you folks, so I thought that might be you, but I don't think it is in the end. But that's just you're the board and working with people. So real generally, your purpose is to hear appeals by people affected by decisions of a code official or a notice or order issued by a code official. That's about as general as I could get it. This is more in your code, responsible for enforcing minimum maintenance standards. I'm sorry, code enforcement. Let me back up. Your purpose, of course, you're directly involved with code enforcement regularly. So what's the difference in yours and theirs? I wanted to throw that up there so we could take a look at what code enforcement's responsibility is. Their responsibility is looking at what the code says, inspecting properties to try to determine consistency between those properties and the code, and trying to bring about consistency between the properties and the code, the various codes. So there's a lot of specifics in there, but as a general rule, again, they're the enforcer, if you will. I don't have a slide about the city council, but obviously the city council is the lawmaker. They decide what codes to adopt. The policy maker, they decided that it was best for the city of Clinton to have some codes in place, to hire staff to enforce them, and to have a board in place to kind of oversee the code enforcers. So this looked bigger on my screen. That's impossible to read. So don't worry about reading it, and this is just pulled from the code book too. Some of the highlights when it comes to your code enforcement duties for the staff. They look at occupancy, exterior conditions, interior conditions, nuisance abatement, some of the primary areas they'll look at. Do the properties they're inspecting, working with, meet the obligations of the code with regard to those matters. So Housing Board of Appeals, just doing an overall review of the Clinton City Code and trying to determine what chapters would bring you into play. And Chapter 90, Nuisance Abatement, which is also referenced at Chapter 154. Chapter 104, Registration of Abandoned Buildings, 150, Dangerous Buildings, 154, Building and Housing Codes, 155, Minimum Health and Housing Standards, and then 155A, Property Maintenance Code. All include provisions that allow aggrieved citizens and others to appeal decisions of code enforcement to you. And I guess the question I would ask, how often, which chapter do you see the most? Do you have an opinion on that? Which of those chapters?
Right now, it's the vacant and abandoned and then
Okay.
the National Property Maintenance Code.
Okay. Are the
What does dangerous buildings fall under?
150.
Chapter 150?
Not my question.
Oh.
What is would you consider, when you look at abandonment and does dangerous buildings come into it?
Charlie, can I ask you to turn on the microphone, please? Thank you, sorry.
Does dangerous buildings come under the abandonment of buildings and that, or do you have to actually?
We hit them with every one of them. It does fall under the vacant, a part of it, also property maintenance, but when we go out and we view a property, they're gonna get hit with every code that's out there.
All right.
Yep. Yeah, I think there would be times you could have an abandoned building that might not be a dangerous building, but there's definitely times, probably more often than not, that they both come into play.
And it's just the city, we started that, quite a few years ago. We go out, we're gonna hit them with every code, even though property maintenance kinda wraps it all up into one as well, but if we end up in court, it's more documentation to prove that our case to the judge, that we've got all these violations. It's not just one code, there's several codes.
And to make things clean, one of the things that Lynch Dallas has been doing, and Tammy and I, and with Lisa and the council's help, is we've been taking the ordinances that you just have here, and we're eliminating conflict, we're eliminating anything that, so you read chapter 90, and then you go to the dangerous building, and it's going to be the same. It's going to point to each other, so there's not going to be any conflict. So, excuse me, if a citizen wants to know about a dangerous building, and they go into vacant and abandoned, the vacant and abandoned will refer them to the dangerous building. So what we try to do is we're cleaning all that up, so there is no confusion. So when you get a case in front of you, the reason it's so many, might be 90, 104, 150 is because each one points to the other.
Okay, thank you.
Okay, then jump to this next one here. And one thing I will say with regard to all of these chapters for today's purposes, I didn't get into a lot of depth with the provisions of those chapters. They're in your code. A few of them we'll hit on. But again, the council passes the code. Code enforcement is the duty bound to enforce it. Appeals come to you. When they come to you, you'll get the specifics. Not that we can't look at them in advance and try to have a good feel for what the code says, but my focus today will be a little bit more on what you do when things come to you. So I won't get into the section by section, but we will have some references. So Chapter 90, and I just went in order of these chapters, 90, 104, 150, 154 as we run through these. Just generally a definition of a nuisance. So these could come to you, a very general, common definition in all communities. And the provisions apply to all residential and non-residential properties located within the city. Then nuisance enumerated, 90.02, would give a laundry list of things that can be considered nuisances. So request for hearing, jumping down to this 90.10, any person ordered to abate. So you get an order saying, we found nuisances at your house, the person disagrees, what do they do if they disagree? They can, of course, and this almost always happens, it starts with a conversation between them and code enforcement, trying to reach a resolution and see what can be done, either to come to agreement on what exists and whether it's a problem or not, and if it is a problem, what do they need to do to make it right. I would think there's probably no cases where unless there's no homeowner or no person to talk to, code enforcement always tries to resolve it short of a citation. So once the citation is issued, there can be a hearing request, and then at the conclusion of the hearing officer renders a written decision as to whether a nuisance exists. And that's prior to it coming to you. Then appeal from that decision may be taken to your board at a time and place fixed by the board. We aren't going to focus on this piece of it either, but as we go from different chapters, they don't all have the exact same time frames as far as when an appeal must be filed by and when you must hold the hearing, but the code says it. So it is laid out in the code. They just aren't all identical. During the hearing, witnesses can be called, evidence offered, argument relevant to the issues, etc. The finding of the boards will be conclusive. In all of these cases, too, when we're talking, your board is considered an adjudicative body. So you're adjudicating, kind of like a court, or a jury would. And I don't know if you do this in practice, but when you have these hearings and there's witnesses, whether it be code enforcement or the appellant or people on their behalf, they really should be sworn in. And I don't know if you do that or don't do that. Okay? And we'll get to that later. I think I cover that later. So, let's talk about Chapter 104, Abandoned Buildings. Requirement to register. Under 104.02 and 104.3 kind of cover the meat of this chapter. If you're going to have a vacant or abandoned building, the city code requires that it be registered with the Building and Neighborhood Services Division, and it talks about how registration is supposed to happen. And then there's some provisions on renewal of registration, payment of fees, and who is to do that, the agent or the owner-operator. Penalties for failure to register, renew, revocation, reinstatement measures. So now we're getting into the things that code enforcement could do to penalize someone that could then be appealed to your board. So the appeal process under Chapter 104, request a hearing in writing. A timely basis means within 20 days or whatever stated in the order, whichever is longer. So it's possible that the order issued by code enforcement could say, we're going to give you 60 days. We're going to give you a lot of time because we just want this to be worked out. But if they give them more, great. If they don't, then it's 20 days under the code. If no appeal is filed, there's a conclusive presumption that the building is appropriately on the registry, and all further appeals shall be waived. So once they miss their appeal period, and let's say they're a month past it, I didn't know I got this, whatever, I want to appeal it. You're really out of luck. There's no recourse once that time frame is gone. But for the potential exception at the bottom, and you can read this exception two ways. So if no appeal is timely filed, but a request for additional time is made, and this is what I added, before or after the appeal deadline, an additional 10 days to file a request for appeal could be granted. So here's the two options here. You've got a 20-day appeal period. You're on day 19. You realize that your appeal period is about to expire. You submit a request for additional time to put your appeal together. Clearly, that's a timely additional request for time. Let's say your 20 days is done. On day 23, you realize you come in and you ask for an additional 10 days. The code isn't 100% clear if you can file that request for additional time after your appeal period is expired. I think, in just thinking of how the courts would handle it, I think in a situation like that, if the request for additional time was real close in time to the expiration, you would be within your power to grant it. Typically, courts like to allow things to be handled on the merits as opposed to you missed a deadline, therefore you lose. So that's just something to keep in mind. If they show up 3 months later, I think that's too late. So 104.11 has the actual language. This prior slide is kind of my take on the appeal process generally, and this actual language, again, may have a hearing within the time stated in the order. Normally 20 days, additional 10 days as noted. And when you're considering the additional time frame to request the appeal, the applicant should show exigent or unforeseeable circumstances making it impracticable to file the appeal within the time provided. They were out of the country, things of that nature. Yeah.
I have a question. I'm guessing here, and that's not a good thing to do, but so when they are asking for additional time beyond the appeal date, that request would go to the code enforcement individuals, not to us.
Well, it would probably go to them.
Yeah, so then that would say, you know, is it within that close range? Is it appropriate before it would come to us as the appeal?
Yeah,
Am I
think
correct?
if it went to code enforcement and they felt comfortable with it, they could grant that additional
Yeah,
time.
that's what I'm trying to get.
If they said no, then that no could be appealed to you. Yeah. Okay.
Tammy, we would usually, if somebody even 10 days later, if we got that appeal and we hadn't started a whole lot of things, or we have started stuff going to legal with it, we usually approach legal and say, hey, we've got this.
I thought that as well.
You know,
Yeah.
they called, they submitted it. Legal usually would say, just take it.
Yeah.
We'll go from there. We always want to err on the side of caution, and we want to work with people. We don't want to always bring them to you guys either, nor do we want to take them to court.
Right.
We want them to take care of their stuff on their own.
And the other way we look at it most of the time too is if this stuff ends up in court, when we end up presenting evidence or talking to the judge about it, we want the judge to think that we were as reasonable as possible and solution-oriented as possible. So denying appeals and, you know, not letting people have their day in court with us, if you will. Not that we didn't have the right to do it, but it doesn't look as good.
We've had appeals that you've heard that were filed 10 or 15 days past the deadline, and we still allowed them. One of them because they sent it to the wrong address. One of them is there was some confusion. So we allow it. There's only been one appeal that we've ever denied, and that person filed the appeal 110 days after the notice, and that was denied. Other than that, we've had appeals that were late, and we still heard them.
Yeah, I recall that. That was my question, and the next thing was that if for that like 100-day one, it wasn't, that individual could appeal to us still?
I think so.
That was
Yep.
my next question.
And you'd be looking at it from that last sentence standpoint, you know.
You know, we've had people that they're not working with us, they don't respond. We've already moved towards going to legal. Legal's has it, well, then all of a sudden they get that the notice of citation to appear for their initial appearance in court. They'll reach out, and we'll work with them. We usually tell them still to go do that initial appearance, plead not guilty, and then we work with them from there. So, I mean, our ultimate goal is to always work with the owners. Yeah.
So then you have your hearing. You've got a valid appeal or appeal that's been allowed anyway. Under Chapter 104, the rule is that the hearing gets set as soon as practicable after receiving the written appeal. The applicant gets written notice of the time and place at least 4 days prior to the hearing, and they give an opportunity to be heard and show just cause why the building does not meet the criteria set forth in the chapter, or why an extension of time to correct the noted issues is needed. And then you make a written decision at the end of the hearing process. So you have some discretion. I think, you know, primarily your role is what you got from code enforcement consistent with the code? You know, did they read the code correctly? Did they apply it correctly, et cetera? There is some leeway to do some other things, and one of them is set forth in this section, why an extension of time to correct the notes issued is needed. So, again, typically, those discussions will have already happened with code enforcement, and code enforcement will likely have already given them additional time and been reasonable with them. And, you know, in these hearings, of course, you'll hear from Tammy, or you'll hear from Rich or Lori, somebody, to be able to give you all that background. And then if the appellant is here saying, I need more time, then you take all that into account in deciding how reasonable that request is. But you do have some discretion there. Post-hearing, if you find that the building is appropriately on the registry, and order the applicant to follow all the requirements with whatever additional time is reasonable. And so if you provide some additional time, if you do grant additional time, there'd be a non-negotiable deadline for the correction, and further rule the building be placed on the registry if the corrections are not timely made. And then your action shall be the final action of the city. Enforcement shall be stayed if you give additional time and during the appeal to you. So if the code enforcement, and this would be true of basically all of these actions where there's an appeal to you, if there's a valid appeal before you, whatever they've been ordered to do by code enforcement, they don't have to do until after their appeal. And I think I'll mention it later, but just to be on the safe side that I don't forget it, if somebody doesn't like your decision, your final decision, whether it be the appellant, or it be the city council, or it be some other negatively impacted resident, their step is to basically take you folks, your board, to district court. I don't know if that's ever happened, but somebody could file what's called a writ of certiorari, basically, and they can't question on appeal your factual determinations, just your legal determinations, whether you made a correct and appropriate legal decision. And that goes to a district court judge. They can set a hearing if they want to, or they can decide it based on written submissions, but very seldom happens. Dangerous buildings chapter is next. These are not Clinton pictures, but they are not. But I've seen some that would maybe have some resemblance in a couple cases. So again, just a few code references without digging into all the references. We have chapter. When you go to all these chapters, they almost always start with a purpose. What's this about? And there's almost always a definition section. So when you're going through the chapter, if you read a section, say, well, what's this term or word mean in this chapter? Because it might not have the same meaning in all cases. They'll be similar, but sometimes different. So if you're reading 150.06 and it talks about dilapidated building, what's that mean? You should be able to go back to 150.02, look at the definitions, and maybe get a better feel for that. So again, the dangerous building purpose is laid out there, and then there's a lot of definitions. Enforcement, building and neighborhood services director or designee authorized to enforce. Housing inspector, fire marshal, etc. Abatement, anything after inspection deemed to be dangerous is defined in this chapter, declared to be a public nuisance, shall be abated by repair, rehab, demo, removal, etc. So if we had a case that came to our office to file a municipal infraction on, so this really wouldn't involve you much, back to an earlier question though, you can see right here under 150.04 it references nuisance. If a building fell under this category, we'd cite both of those chapters in our action before the court. So then there's notices and orders. Those are the kind of things that can be appealed to you, that get distributed by building and neighborhood services staff, if you will. Notice and order be directed to the owner of the building, and then the code provides what's to be in that order. So it spells out, so if Rich or Tammy are giving out an order under this chapter, they would look at 150.06 and they have the forms and be sure they cover all of those elements that are required. And then here again we have appeals. Any appeal can be made against, if you will, based on the action of building neighborhood services by filing a notice of appeal at the office of the building neighborhood services director. The appeal shall be filed within 10 days. Upon receipt, the building neighborhood services shall present it at the next meeting of the Housing Board of Appeals established in the International Residential Code. So again, it doesn't say within 20 days as reasonably as practical. This one says the next meeting. Disposition of appeal. After hearing all testimony concerning the appeal, the board will have 20 days to issue a finding in writing containing findings of fact, determination issues presented, and the requirements to be complied with, and then mailed to the person appealing by regular mail and filed with the council. The reason it gets filed with the council, again, some boards with the city make recommendations to the council. That's not what your purpose is. Files with the council so they know what you've done. If they are unhappy with it, that would put them in a position to file a petition with the district court saying they think you made an illegal decision. So that's the only thing that happens there. There's no council action required. It just goes to them so they're aware. And then I mentioned that appeal to district court there. It's actually referenced in 150.09 as well. Okay, going to go to building and housing codes. Chapter 154, the city adopted the state building code. I just highlighted one thing here under amendments and exceptions to adopted fire and building codes. Down a ways under duties, talks about the Housing Board of Appeals shall include the authority to consider and determine appeals filed pursuant to Chapter 90, the Nuisance Code. And then this, any member of the board who is a landlord or lessor shall recuse themselves from the discussion or voting on any nuisance abatement appeal that involves a landlord-tenant situation. So if any of you, in any specific situation, had to recuse themselves, I made a note at the very, very bottom that a recusal is the equivalent of an abstention. So right now you have a 7-member board, requires 4 votes. If somebody has to abstain, it's as if your board is now a 6-member board. Okay, so you still only need 4 votes. If you had 2 abstentions, now you got a 4-member board, and you need 3 votes. Hopefully that doesn't come up too often, if at all, with the people on the board. But that's just a little tidbit in there that you need to be aware of.
Can you clear that up a little bit? Because I know we do have a board member that's a landlord, and that talks about nuisance. So
Yep.
what happens if I file a 155A violation against the landlord for lack of maintenance, so it's not a nuisance?
Mm-hmm.
Would a board member who's a landlord cannot vote on a situation like that? It's not tenant related.
Yep.
It's
I would say they would not have to recuse themselves unless they had other reason
right.
that they thought in that particular case they should.
'Cause I knew that Ray would ask that if she was here. I know she's
Okay.
here today.
Yep. Yep, this one only deals the specific language nuisance abatement appeal involving a landlord. So, yeah, a rental situation nuisance. So just 154.20 building housing codes was adopted, provisions for variances, reasonable variances for existing structures which cannot practically meet the standards of either the housing code or chapter 155 but are not unsafe for habitation may be granted by the housing inspector or upon appeal by the Housing Board of Appeals. My take on this provision, a couple things. One, if there's a request for a variance, it should be made to the housing inspector. It shouldn't be made for the first time to you folks. It should be made to the housing inspector so there's that opportunity for them to discuss it, debate it, see if there's some way they can resolve it. It shouldn't come up first on an appeal. So when it comes to you and somebody wants a variance from the requirements, so there's a notice issued by code enforcement that's fully consistent with the code. The applicant or the appellant doesn't like it, they appeal it to you. They come here and say, the code enforcement folks are totally right. However, for this reason, I should get a variance, and I've covered that with code enforcement, and they disagree, but this is why I want a variance. A variance for any provision of code should be granted in a very limited basis. The idea behind codes is that the code exists to treat everyone the same. So if you start making special exceptions or variances for people over and over and over again, you're allowing the code to treat certain people one way and certain people a different way. So, yes, sir.
Can you give an example of what would be practically unsafe or would be granted okay?
Let me think about that for a second.
I think I can.
Yeah, go ahead, Rich.
We have an apartment building downtown that has bedrooms with no windows, no form of egress. Those apartments have been apartments for 50 years. They were granted a variance because technically those built bedrooms are unsafe and in a fire they would, but the city agreed to grant them a variance because the building had other things in place to protect the occupants. So I don't know if that makes sense to you, but I think that would be a good example.
So they fit whatever they could do, whatever those conditions were, they could make it so it was not unsafe for habitation.
Correct.
Even though
It doesn't meet code in any way, shape, or form, but
Yeah.
they were able to make it where it would meet, it wasn't unfit.
Yeah.
So years ago, they allowed those apartments, and the apartments are now closed for other reasons, but that was good examples. The city moved forward and said, hey, you can't have those as bedrooms, there's no egress, no that. The landlord put things in place, and the city granted a variance because of the items in place to protect the tenants.
when you say the city granted it, who actually made that decision?
I believe it was city legal.
Okay, I bet city council or, yeah, okay.
I have a question on the same thought, just thinking of what might come before us. It makes sense to me about the variance being issued by the code inspector. What if the individual makes the appeal, had not addressed anything about a variance, comes before us and all of a sudden presents the request for a variance, and they have not even discussed it with code.
Yeah, I think you have a couple options, and we'll cover this a little bit later too, not exactly on this specific question. But I think if it's clear that this is something new that has just popped up, depending, if code enforcement is ready to address and say, this is why I would not think that makes sense, or it could make sense, however, there'd have to be some other things done, kind of like the building example, where maybe if you do this, this, and this, we can let you have bedrooms downstairs, even though they don't otherwise comply because there's no ingress egress. So if it looks like there's a code enforcement is prepared to address it, I would allow it to be addressed and move. If it might require further investigation or discussion, I think you could adjourn the meeting to be reconvened at a later date and allow code enforcement to maybe work with them.
That was my question. Okay, thank you.
Question on that same note. Like a building like that, are they grandfathered in? Because it's been that way for 50 years, and now we have the building code and that all of a sudden.
Don, can you please turn on your microphone? Sorry.
Would that be grandfathered in?
Yeah. I'd say a couple things about that. Possibly yes, and possibly no, which isn't necessarily a great answer, right? Grandfathering in general, that term, a lot of people like to use it, and it's a valid term, and it sometimes has a lot of meaning. Other times it's not really a law. Something being grandfathered isn't necessarily a law. However, when you pass new code, you can't apply it retroactively to property unless things happen with that property that make it all of a sudden now subject to that code. So you might pass a new code because that building in my book would be called an existing non-conforming use. Permitted non-conforming, okay? Because it was good to go, it was totally legal and operating, and then the city decides to pass a code over here. Okay, this thing's running. It's got 50 apartments, they're rented, whatever. The new code says we aren't going to let another one of those get built without ingress egress windows, hardwired smoke detectors.
Right, that makes sense.
Yep. So then the code might say, if we've got some of these existing buildings like that, if they cease to operate for a period of a certain amount of time. So this building owner, their tenants are dwindling, they aren't really maintaining the building, it gets boarded up and it sits empty for 6 months, 9 months, whatever the code over here says. And then somebody buys it and wants to make it into apartments again. Now they have to comply. Does that all make sense to that answer?
The other thing where there would be a change is if it's a change in occupancy. Like the example I gave downtown, it was a storefront, it was a business, and the owner of the storefront lived upstairs. So it was a store and owner occupied. The owners sold it. Whoever bought it left the store but started renting the upstairs. When the city found out about it, we came in and said, oh, no. Your upstairs doesn't meet rental code. It doesn't meet 1 to 55, so you can't use it as rental. They then began to communicate with the city, ultimately. And again, this is even before I was involved in the office. There's a lot of communications, and ultimately they installed certain smoke systems and other things in an agreement with the city, and then ultimately the city agreed to give them a variance allowing them to have it as a rental. But if you went into it before it closed, you would find apartments with no windows at all, which don't meet code, but the city working with the owner. But the reason it was forced to change is because they changed the occupancy type. And that happens a lot. We'll come into a property and they'll have it as a privately owned, and then they want to rent it. Now they've got to meet the code because they're changing the occupancy.
No, that makes sense because they changed hands.
Right.
Yep.
That answers my question. Thank you.
You bet. This is what Tammy gets and Rich gets, right? What code violations? Okay, again, not Clinton, but we've seen really close, if not worse, in the recent past. Sadly to say.
I was in that bathroom yesterday.
There was also for sale recently on Market, and I think it was posted just like this, as is. Did you guys see, maybe?
They advertised it this way?
It was for sale, I mean, the sale is going to be as is.
Yeah.
And I felt bad when I saw that, yeah.
we were in court a month or 6 weeks ago with a couple different dog cases, and I went home at night and had a heart-to-heart with my dog on how good he has it. It's just, in the cases we had, not to get too off point, the two owners went to court. They definitely, in their heart, love their 17 Chihuahuas or their 7 pit bulls that they don't even live with. They do. But then when you look at the way they allow them to live, do they really? But I mean, it's just, it's unfortunate. Unfortunate. So anyway. So this is the rental property code, known as the rental property code, minimum health and housing standards required for rental properties. And I won't read the 15503, but again, like all those code sections, there's always a purpose statement, and it's to provide, safe and quality housing for those renting. No housing, I just highlighted one point here that I wanted to bring to your attention when it talks about authority of the housing inspector. No housing inspector shall inspect a property in which the inspector has financial interest or which is owned by someone related to the inspector. Sounds obvious, but it's specifically spelled out in your code. And obviously there'd be a conflict of interest there or a strong appearance of conflict. Minimum health and housing standards. Evidence obtained by, and this could come before you at some point, as I know at the bottom. So it talks about evidence. If a housing inspector did not first make reasonable effort to obtain consent to conduct an inspection, basically evidence they obtained during an inspection where they didn't make those reasonable efforts, you really shouldn't consider. So if there's an appeal to you under this chapter, and the argument is all this stuff they're telling you they shouldn't even know because they were illegally in my property. If that would be the case or the argument, before you get into the merits of what the inspector saw or is complaining about, you should first address the issue of access and how you got that information and did you make reasonable efforts to obtain consent. Kind of a two-step process. And then you make a decision on that. Okay, we find that there were reasonable efforts made just because you never picked up your certified mail or, in the letters, we've got proof they were sent to your address. You admit it's your address just because you didn't read them. That's not on the inspector. But if the inspector says, I went and knocked on the door a bunch, but I never got them. Yeah.
To maybe a follow-up question to that, when we receive appeals, sometimes we receive information that there are no utilities. So does code enforcement have to ask permission to run a check like that to make sure that there are no utilities in place?
No.
Okay.
No.
Okay.
That would be, a lot of that's available through the city, so it'd be public information. And yeah.
Okay. Thank you.
They don't have to worry about that. But they do have to make an effort to, get in, reasonable efforts. And sometimes, too, there may be cases that would come before you where the evidence that the city's using as a basis for their notice to abate or their order was obtained by them after getting an administrative search warrant, where they've gone to the court, actually got a court order saying you can go in that property.
And we do have the plain view doctrine.
You do.
Which means if Tammy or I or Lori or somebody code official goes out and we're standing on the public sidewalk and I can see the meter head, the meter base, and I see that the meter's gone, that tells you right there there's no power. So that's what we do. We really do our best to make sure we don't break curtilage. So that means we don't walk on the property where the public wouldn't normally go.
And you can walk up to the door of the house because that's kind of an invitation to the public. Go up, knock on the door, and see what you see. And you can get permission from a neighbor to go in a neighbor's yard and hold your camera up and take pictures in the backyard. And so there are definitely things that are perfectly legal. Okay, and I apologize. This is really small too. This is the exact language with regard to appeals, defenses to enforcement of rental sanction. So it talks about, again, what an appellant needs to do to bring this to you. So it's a written petition requesting the hearing and specifying the grounds within 20 days after service of the notice upon the appellant. It goes to the housing inspector, who will set a time and date for the hearing within the time as prescribed by the general rule of the Housing Board of Appeals. So again, not all these chapters have the same time frames for hearings. Shall take no further enforcement action by code enforcement pending the hearing, so there's a stay. And then once that's all set up, the housing inspector forthwith transmits to you folks, so you know that there's a hearing coming up and the details, etc. The hearing shall be commenced not later than 30 days after the date on which the appeal was filed, and the housing inspector may postpone that date for a reasonable time beyond the 30-day if there's a justified and sufficient reason for the postponement requested by the appellant. Sometimes you'll see in the code, or referred to as the petitioner, I use the word appellant because they're appealing a decision. So they're kind of interchangeable, though, because the petitioner is the one petitioning you for action. So appeals, defenses to enforcement of rental sanctions. At the hearing, they'll be given the opportunity to be heard. You have a 5-day window to enter your decision within the public record with the Office of the Housing Inspector. The record should also include all those notices that support the decision. The decision to also notes or says the decision's to be entered without unreasonable delay. Chapter 155.18 talks about defenses again to rental sanctions. I highlighted the permit shall be deemed to have been revoked. So at a hearing when there's been a notice suspending a permit required, or by rule or regulation, the notice considered the Housing Board of Appeals, the permit shall be deemed revoked. Any permit that has been suspended by notice shall be deemed automatically revoked if there is no petition or no request for a hearing within 20 days. So kind of talks about the failure to file an appeal, kind of the finality of that. (155.18) tells who can appeal. So you've got any person or persons jointly or severally aggrieved. So you could have an occupant of the property, you could have an owner or a joint owner of the property that doesn't like your decision. Shall have recourse to file recourse with the district court. 155, just a few more specifics there. This is a long code section. If there's an emergency, so not just your normal notice of appeal, but if the inspector finds this is a real emergent situation, they can request immediate action. The inspector may call for an emergency meeting of this board. I don't know if you ever do that. No.
We've not had the situation arise yet.
Okay. If that would happen, there's rules anyway that lay out the steps. Again, a meeting as soon as possible. No event sooner than 24 hours after notice given to the owner of the premises of the time and place. Notwithstanding other provisions of this chapter, in this case, all other cases we've got, if there's an appeal, there's a stay. In an emergent situation, the order is effective immediately. They need to comply immediately, but they still have a right to request an appeal and have a hearing. An appellant is allowed a defense to an enforcement action if they can show you one of these things. That there's the alleged violation has been reported by the owner to law enforcement, so they're trying to deal with it. That there's an eviction or attempt to evict a tenant. And I will say with all of these, the notice of violation or the order that they're upset with has to be affiliated with these things. It can't be like your roof's caving in. Well, I'm trying to evict my tenant. You know, there's a connection here. And this, and then if it's a first offense undertaken and pursued with due diligence, reasonable means to avoid a recurrence. So there's some defenses they can present. The two most important ones there is they've got a situation where they're trying to resolve it, basically. We're making our good faith effort to resolve it. Law enforcement's involved. I've got an eviction going. The only thing I'd say with regard to evictions, if that might be the right answer, are they really making a good faith effort to evict? Do they have a lawyer involved? Have they actually filed the paperwork? Or are they just saying, well, I've told them to leave? So I think that happens once in a while where the landlords may not truly be in good faith pushing an eviction. They might just say that they want to. And sometimes there will be cases where they really want the city to do it for them, which really isn't the city's role. Okay, here's, you turn off the main road, you have to be prepared to see some funny houses. So that happens. International Property Maintenance Code. So this is kind of, again, the primary area where you'll be dealing with some things, I believe. International Property Maintenance Code is intended to establish provisions to protect the public health, safety, welfare, try not to unnecessarily increase construction costs, do not restrict use of materials, and do not give preferential treatment to certain classes of materials, products, or methods of construction. This was adopted in Clinton in 2008. It had been talked about, brought up by a neighborhood improvement committee led by citizens. Brought up other codes in 2008, International Fire Code. This was adopted in 2020. So prior to that, there was no provisions regarding maintenance of owner-occupied structures. And again, this is minimum housing standards as stated. And this is off the city's website. Minimum standards to ensure that every resident can live in a safe and healthy environment. Covers following topics. There's really 8 chapters. The IPMC are eight sections: scope, administration, definitions, general requirements. Then it gets into light ventilation occupancy, which talks about minimum requirements for those topics: plumbing, mechanical, electrical, fire safety, and then reference standards, which is a comprehensive list of standards referenced in the code. 155A, property maintenance. Designate responsibilities to maintain things, maintain structures, to define nuisances, and again, referring back to Chapter 90, there's a lot of back and forth with these chapters. Provide for safety and preserve the health and welfare of the citizens. Again, another standard provision in all of these chapters: who is to enforce these provisions and how that works. And then the adoption language, 155A.06. Then request for hearing. Any person ordered to abate a nuisance or interested therein may have a hearing with the Housing Board of Appeals as to whether or not a nuisance exists, and request an extension of time within which to abate. Like the earlier comment, this should really be a discussion, and probably already has been a discussion with code enforcement, and they've probably already given extensions. But it doesn't mean it can't be brought back up. Hearing must be in writing, the request, within the time stated in the order or within 20 days. Again, very consistent with the nuisance code. Talks about postmark dates as guiding that. Additional 10 days to file requests may be made. Hearing as soon as practical after the written appeal. Advised in writing the time and place of the hearing. After the hearing, a written decision, etc. At the bottom, if you order additional time, the finding of the board shall be conclusive. And like other chapters, this is all stayed pending your appeal. So when it's appealed before you under 155A, the appellant or the petitioner doesn't really have to do anything until after your decision. Talks about emergency abatement measures. The code official can decide that things are immediate threats to life and property, and without notice can order those nuisances abated with costs assessed against the property. This is rare circumstances and should only be utilized by code enforcement when it is very, very clear. Okay, so you have some rules that you've probably all seen, and I just stuck some of them in here. So when your procedures when hearing appeals, you record the folks present, board members, city staff, the petitioner and or representatives, others in attendance. Determine if any board member has a personal conflict, so cover that before you even get into the meat of the matter. Read an opening statement given in the summary of the city staff report. Remind those present that it is a hearing of the facts and not a courtroom. So while you're an adjudicative body like a court, the procedures are not as strict as you might see in a court, a lot more loose, if you will. There not be any type of cross-examination by either party, such as there would be in a normal court. And I'll touch on that a little bit later, too, when we talk about if somebody brings an attorney with them, how you handle that. And then you have a presentation of facts by city staff, presentation of facts by the appellant, questions by board members, and I think really, quite honestly, during either presentation, you can interrupt and ask questions whenever you want to. Totally up to you how you handle that. If you'd like to let both make an opening statement, you sure can. Any further information for the board from city staff, any further information from the board for the appellant. And then upon motion second, the board adjourns and reconvenes at the site of the building if you want to. Obviously, you don't have to ever do that, but if for some reason you think it's important to actually see the property, you can do that. So you adjourn, reconvene at that site, and inspect, look at things, and then that's a continuation of the hearing once you're there. If you, whether you do that or not, at the end, there's a motion and a second. either to affirm, modify, table, or reverse the notice and order or action of the code enforcement officer. So the motion second, call for further discussion, conduct a vote, and then adjourn. Okay. The hearing process generally, that was from your rules. Here's some notes that I made when just general hearing operations. You open the meeting, approve the agenda, and this gets back to an early comment. I would at that point say, who here is going to be offering evidence or testifying before? I would, for what it's worth, have them raise their right hand. You swear and affirm to tell the truth. Say, I do. I do them all at once. That's done. Then you have the code enforcement presentation explaining the background, the basis for the action under appeal. Questions for code enforcement by board members. The appellant presents explaining the basis of their appeal. Questions of appellant by the board members. And then follow up by code enforcement and or the appellant, or questions by appellant to code enforcement or board. So not really a cross-examination, but if the appellant doesn't, if they say, I just don't understand, and, Rich, why did you say this when it's really like this? I think there can be some of that, but I think you also want to have some control over that it doesn't turn into a total back and forth between code enforcement and the appellant. And then announce after giving the final opportunity as noted above to be heard that the record is closed.
I have a question
Yes.
back on that, just because we've had a discussion about this. If the appellant comes in and somebody else is with that person that is not directly tied to the situation before us, and they want that person to address us.
I think if you ask who is here going to offer testimony or to be heard, and the appellant says me, and somebody else said, you can ask, please give us your names, and what's your relationship to this? And if that person says, well, I'm just here for support, what is it that you without telling us your testimony, what is it you plan to testify to? If it's nothing more than, well, I'm just good friends and I've been in the house. It may or may not, you might be able to rule some people out. They may even say, yeah, I'm just here for support. And it's like, okay, well, you can sit down and you can sure be here, but at least you'll know then. Yep. So when the record is closed, that just means that you've heard all the background and justification, and then now you deliberate and decide what you want to do. And that can happen quickly, or it can take some discussion. So the chair can announce that it's now time for deliberation or discussion, or that just naturally begins, or you can have a motion followed by a second. And then I noted Robert's rules. Every board handles this differently. Technically, under Robert's rules, you don't have discussion until you have a motion and a second, and then you discuss. 90% of the communities I work with, usually there's discussion to get a feel where you're headed, and then there's a motion and a second and a vote. You don't have a legal obligation to follow Robert's Rules of Order, so whichever way you want to go there or traditionally go there is fine. So you can start with a motion, second, then discussion, or you can have discussion followed by a motion and a second. This is just kind of my take. I think in most cases that come before you, it'll be pretty clear what your decision is going to be. Most likely, most of the time, the code enforcement was doing the right thing by virtue of what the code says. So you don't have a requirement to debate for any length of time. Once you're done, you can have a motion second, any further discussion, and then you can vote to affirm or modify whatever you want to do without discussion. Just a few other notes there. A motion, if it's not simply to deny the appeal, affirm the decision. If there's any nuances in there, make it as specific as possible. So if you are granting some additional time, or in what your expectations are to happen within that specific time, try to be as clear as you can. So that information is not only in the minutes, but in a decision that would get issued afterwards. So chair can always ask, is there any more discussion? When there's no more, then you call for a roll call vote with a record made. After the vote, you announce the decision, explain that it'll be reduced to writing. I always confirm the address and mailing information of the appellant. That way it's on the record that they told you where to send it. And then when the decision's done, it gets mailed out. This is a question that we haven't talked about. Who puts that decision together and how soon does that happen? One of you two. What do you do so the board makes a decision. Let's say it's something more than affirming, there's affirming or denying, whatever the case may be. There are some additional conditions or provisions. You put it together. Does it go back to the board for final approval then?
The chair comes and signs it.
Okay, perfect. And I think that's adequate. I think if there was ever a case, and I think I mentioned it later, if it is significantly detailed and the chair is like, you know what, I really want the board to be sure this is what we're all on the same page, it could be distributed to the board. You don't want to have an illegal meeting, but it could get sent out. You could call for a quick special meeting and vote on it. And that probably is rare, but if it was ever so full of details and exceptions and deadlines and expectations, or if there was not full agreement on the board exactly, maybe it was a split vote, then maybe bring it back for everybody to review. If they say they need more time and the board deems that appropriate, I would try to really determine how much more time. And are you just throwing I need another 90 days. Well, why do you need 90 days? Could you really do it in 30 days? Try to dig into that and try to put the appellant in charge of that discussion. So when the ruling comes out, it's based on what they say they wanted almost. So it makes it harder for them to argue about it later. Now, if they're totally unreasonable and say, well, I need another 2 years, you don't have to put them in charge of that. But if you want to say 30 days, but they say, well, I know I could do it in 45 days, go with the 45. So it makes it much harder on them to come back later and say, well, yeah, I need more time again. Keep in mind, as is almost always the case, code enforcement has already made that kind of effort with them. The benefit of putting them in charge, they did not comply. They are failing to comply with their own proposed resolution. Here's some practice pointers. When you have a final decision in writing, try to have, you don't have to put headings necessarily, but findings of fact. What is it that the board found to be the facts? Conclusions. So you've got facts, you've got the code. How did the facts that you found when applied to the code reach the decision you've reached? Explain the reason for approving or denying a request for additional time. So if they requested time and you denied it, or you requested, you gave them 30 days, make a note of that. The appellant said they could fully comply within 30 days, so we agreed to give them 30 days. Clear statements with regard to deadlines. Clear statement that the written decision is order and it is final, that there will be no further consideration by this board. We kind of covered this, and before asking the question, like I told you, I hadn't really talked to these guys about the details, but typically code enforcement will write the proposed decision or the draft decision for the chairperson to review. Decision will be based upon verbal direction and action of the board. So at your meeting, when you make your decision, these guys will be taking notes or listening and use what you've said or directed them to do to put this decision together. And if it becomes too complex, you can reconvene the board for any final updates or language in the order that one of you may want. What if decision is not clear, you need more information? We kind of covered this earlier. You can table the consideration to a date to be determined at that time. I would try to reach a decision on when you're going to reconvene. That way the appellant's here, code enforcement's here, and the board's here. So in the motion to table, make clear the reason for the appeal being tabled. Make clear what additional information is being requested or desired, so when you come back, you aren't going to be maybe looking to table it again. Again, note while the appeal is delayed that the action of code enforcement is stayed, and note when you'll reconvene. Now, there might be a case where you have an appeal and it's on a handful of issues, and the appellant says, I understand this. I've got 3 junk cars in the backyard, but I don't think my house is a nuisance for these reasons, and you guys want more information, so it's going to be tabled. The decision at that point could be, okay, the junk cars need to go. We're going to rule on that today. We're going to table it on this other issue and come back and address it under these conditions and at this time. So you can have kind of a split decision too. What if appellant brings a lawyer? It's not a formal hearing. It's an informal process designed to get an understanding of the facts of the law and to make conclusions. The chair has a lot of discretion on how you run the meeting. You do not want to be susceptible to an argument that the appellant was not given due process. That's the whole thing behind this, giving them an opportunity to be heard. You do not want the attorney to take over the meeting or dictate the process. You do not want code enforcement to be cross-examined in any manner that is abusive or aggressive. In my opinion, that does not mean you shouldn't allow the attorney maybe to ask some questions. It just isn't, it isn't a case where code enforcement is going to take the witness chair and get drilled with questions. But if they have valid questions that they just want to be sure they understand, loosely, I'll say, they really direct them to the board, and then you can direct the question to code enforcement to answer if you think that's appropriate. You guys have any agreements or disagreements with that? I don't know how often that happens. If anybody brings.
It's happened a few times. That's why the board actually adopted that resolution change, because it actually had some pretty continued arguments start.
Okay. These next two slides, these are just kind of add a little humor to the maybe boring process. Do you think I'll have volume here?
Should we have mine? I think we do. We'll find out in a second.
No volume, I don't think. Is he helping me there?
Oh, the rest of me in there. I couldn't see it.
Maybe it's maybe there it is. Let me try that. So no volume? Okay. See, I forgot to ask that question before we started. Not going to work? Well, what we got here, and it's really very funny. I don't know if anybody's seeing this, but so this is what to not do on as an appellant. In the lower right side of this, the cat is actually a lawyer. And somehow he's got this filter on his screen. So he's in a hearing before the judge arguing his case, and he can't get rid of the cat face. And he's like, you know what, I really am a lawyer. You know, I'm not a cat. He's making this argument just kind of so. So that's this next one. You're gonna lose the total benefit of it, but it was really.
Here, let me see it for a second.
Yeah.
It's this one, right?
Yeah. Well, that's the new one.
Yep.
Oh, okay. I got you.
Any questions while we're? What do you mean building construction?
IPC, IRC appeals.
I think they ultimately, I think they would come to you. When we've had two, both of them were mine. One was a water heater that was installed incorrectly, and the other one was, I believe, a furnace that was installed incorrectly. And both of them were heard by the Housing Board of Appeals, but they were run by Mike Harmon as a code official.
Yeah, different group of officials.
Right.
But sometimes you'll cross over
Yep.
with the rentals.
Yep.
We'll have that, there'll be a time where there's a warehouse along the river that would make a great restaurant. They won't want to put in sprinklers, and it'll come to us. Or they'll want to make it a rental, and it'll be you and the building official.
That might go to zoning.
True, yeah.
But
Yeah.
if it was a construction, example I think you'll agree with. We got a new house being built, and the code official goes in and says, this has got to be a firewall. And the contractor says, no it doesn't, because of blah, 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 blah. I want to appeal that, it would come to you guys.
Sure, okay.
Ron?
Kind of another question on that thought.
I believe you have a filter turned on
Okay.
in the video setting.
You can pause it for a second. Let's do your question. That's more important than the funny video.
So where was I going with that? So, okay, we get we haven't had any of these yet, but building construction appeals will come to us too then. Like if there's questions before the case, I mean, is it kind of can we reach out to these guys in any appeal, or to you, or like where would we get our legal advice right before the case, or in the days before the case?
I typed some notes to myself when I was forgetting things that I didn't address in there, and I've typed here outside conversations. So if there is an appeal and you want to be prepared, right?
Yeah.
I think you very legitimately can talk to code enforcement, because they're the ones who kind of made the decision based on the law that's being appealed. You can reach out to them in advance. You can reach out if you talk to them and you want to reach out to legal. I think you can and should. It's unique because there's also the Board of Adjustment, another board that grants variances on different housing things, and our office as the city attorney. Like mentioned earlier, if the council doesn't like your decision, they can sue the board, just like they can sue the Board of Adjustment if they don't like the decision. So if they did that, then they'd have, we'd be the city attorney, but we also are the people giving you advice, or should be. So I think start with code enforcement, then come to us. There's court cases out there that talk about it's not necessarily appropriate for you to have contact with the appellant and to go visit the property and to have them give you their whole pitch. That really should happen in the public setting, in the open meeting. I think if somebody reached out to you who was the property owner and said, I just want you to come look, I want to show you, I think the best course of action then would be to have the board go, as opposed to one person, and actually have it set as a meeting, and then you'll convene at the property, kind of like we addressed in the other code. So you're all there. It's not just one of you getting kind of some pressure, some outside push to decide a certain way that isn't part of the hearing process.
Sure. So I'm certain we all do this, but before a case, we'll drive by.
Yeah.
Sure. Okay.
Yes.
And we bring that up. We talk about it. Yeah.
You wouldn't talk to the owner of the property
Sure.
one-on-one away from the meeting.
Yeah. And Clinton, I'll say this can happen in small towns, and Clinton isn't that big a town, but if you've lived here long enough, you're going to know somebody who knows somebody who knows somebody. Maybe it's a realtor, maybe it's somebody on the council that knows somebody. Then they're going to call you and say, hey, I know this is coming before you. This is what I want you to know. Those conversations shouldn't really happen. It's hard sometimes because you know the person, you know the connection. So that's just kind of to be aware of, I guess.
And to also prepare for those types of hearings, as you noticed over the last couple of years, as we got new members to join the board, we are bringing the board in line with the property maintenance code. Everybody has the book. You'll notice in the property maintenance code it says you have to have trade knowledge people on the board. And that's one of the reasons for that. But the other thing to be cautious of is be cautious on getting together to talk about something before. Because if you get so many people, then you're going to run into an open meeting and all the other stuff. So just keep in mind that when you nothing stops you from going to people who have that construction knowledge and saying, hey, we're going to be meeting, but just keep in mind discussions amongst yourself, you do run into those restrictions.
Now, there's been times we've had an appeal come through, and Rich and I have talked before. We've talked before about having Lynch Dallas even on the phone if we thought a meeting might need some legal advice into it. So we always have that option that we can call and put them on the phone, put them on Teams, especially if they can't get here or have them here for it. We can always have, if that is the case that we think we need it.
So as a board, you can rely on those trade people. So when you look at the membership of the board under 11 or 111.2, that's one of the reasons we made sure, working with the council and the mayor's office, in the city administrator's office, we made sure that the new members were tradespeople, had that knowledge. So the other board members can also, during the hearing or during the discussion, can rely on So they can actually say to you, Paul, hey, you know, you're familiar with this. Does that have to be a firewall? And you can say, well, code says da-da-da-da-da. You look here. You know. So that's one of the reasons we have the mix-up of the board the way we do. So during those discussions, you're going to have people on the board, hopefully, who are going to have that background to help with that discussion. Does that make sense?
On that same topic, if for something someone would come up and everything that the code enforcement had done provides it, but something pops up that we maybe still have questions and perhaps code enforcement is not able to answer, we still have that power to go back and table, like we just talked about, to get the information as a group, not individually, and then come back. Correct? Okay.
Yeah, and another thing to keep in mind too, if, let's say, Don, you have a question that you think Paul has some expertise on some issue that's coming before you, you can call him or email him and say, what is your thought on this? Tell me more about this. What you have, and any of you can do that. What you have to be careful of is if there's a serial calling back and forth or emailing and it turns into deliberating amongst all of you, then that can be considered an open meetings violation. But if you think one of the other members can help you understand something, or if you want to share with them, you know, this is how I see it. What am I seeing this wrong? You can do those kind of calls, so long as you don't say, well, I'm going to check with you, then I'm going to check with you, then I'm going to check with you, and try to get everybody on the same page.
Can we, like, mid-appeal, can we, like, have our own little huddle? Like, can we take 10 minutes and talk? Or right, or just does it have to be within, as we sit here?
Yeah, I'll say almost always it would need to stay in the open session.
Okay.
Yep.
Okay. So if we do feel a hiccup, it's best to just pause it, come back.
The one exception that would allow you to go into closed session would be if, it's very fact specific, if we could establish that litigation is imminent. So if you had the appellant say, I've got my lawyer and we're going to be taking this to court, but almost always, especially in your environment, you're going to be in open session. Yeah. Yep. A couple other comments I had here in my notes. Your decisions when you are hearing an appeal and it's over, you make your decision based upon what's called the preponderance of the evidence, which is more likely than not. There's the preponderance of the evidence standard in courts, there's clear and convincing, and then there's beyond a reasonable doubt. You hear about in criminal cases. You're kind of at the lowest level. So if you find that code enforcement did what they're supposed to by like 50% plus something, then you decide in their favor, basically. If the appellant convinces you that, well, I pretty much agree with code enforcement, but I'd put it at 49%, then you might grant the appeal. So it's the lowest standard of appeal consideration, if you will, at the preponderance level. Open meetings we talked about. Again, council makes the law, code enforcement enforces it, you oversee all that. If at any point you're involved in a process, you're like, code enforcement, you're right. What you did is right, but we don't like it. We don't not like what you did. We just don't necessarily like that law. While you don't have any power on that front, you can always make a record and make a recommendation to the council that you revisit this. This particular code section, the code enforcement is enforcing correctly. We don't like it, and here's why. So you can always make those kind of recommendations. You don't have the ability to change the law or ignore it, but you can definitely make recommendations for tweaks.
But our ruling would be based on what is currently in place.
Yep.
As a board, two of us agree with the client. The rest, do we got to be 100% like in a jury trial?
No.
Just a majority?
Just a majority.
Okay.
Yep. Perfectly legitimate. Okay. Let's try this one more time. Oh, I'm sorry. Go ahead.
If someone in the audience happens to be a kibitzer, have the chair close that person down and tell him or her to please be quiet?
Yep, I think you can give them a warning. I'd say, if you don't comply, you need to leave. And you can do that. Yep. One thing, and this happened when I was in Monticello as city manager for years, and it wasn't necessarily in this particular board environment, but the city council, the elected city officials, if somebody feels they're getting aggrieved by code enforcement or city administrator or whoever, those people are more likely to go to the city council members than to you. And I had every councilman is a little different. Some are very open to hearing any and every complaint. Others that's for this board. That's not for me. I had a city councilman who was always up to taking those issues, and then he'd take the complaint from the resident, and then he would start calling people on the board, saying, "Hey, this appeal's coming up, and John's getting the short end of the stick on this," and da 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 da. Council shouldn't do that, okay? Because for one, they have a right to appeal your decision, and you don't make recommendations; you make decisions. And I tried to work with that council member to. You need to keep a distance because you shouldn't be impacting the decision of this board. That's not how the law is written. So it's kind of an education process, but that's something that comes up once in a while. So anyway, let's see if my volume works, please.
You know what I'm not.
I wasn't here. No.
We just had that last meeting.
Okay.
We had a council person show at our meeting.
Okay. Yeah. And
I believe you have a filter turned on in the video settings.
I'm not the
You
filter.
might want to.
That is the video.
yeah.
Yeah.
Yeah. Can you hear me,
I
Judge?
can hear you. I think it's a filter.
It is, and I don't know how to remove it. I've got my assistant here, she's trying to, but I'm prepared to go forward with it.
No, Lisa,
I'm
you
here
cannot
live.
do that
I'm
on your
not-
next
I'm not a
team
cat.
meeting.
That's the best line. I'm not a cat.
But I think I want to do it on my next Zoom court hearing.
I can see that. I think if you click the.
Okay. Let's jump to the next one if you have that next link for me.
Doug, can I do that the next time we have a court hearing?
Absolutely. So that's what not to do as an appellant. You don't want to show up for a hearing and be a cat filter.
No, because with your luck, the judge would be having a bad day.
Yeah.
My luck, it would be my favorite judge, and I'm going to get sent to jail.
Now there's
While we're working on that, did you have more? Okay.
Yeah, and with that issue, if you ever did have a counsel, it's not necessarily the easiest thing to say, and I would say typically if they aren't being too terribly overtly overstepping, you can kind of let them say their few words. If you get to the point where you're like, you know what, this isn't your role. I mean, any of you, the chair, any of you can say, this isn't, this is for us. This is not for you. After we make a decision, it will come to you, but you can tell them that, whether it'll work or not. Because again, the guy I had for a long time, and he's a good guy, but he's like, well, I'm elected. I'm elected, and I have a right to say what I want to say. I'm like, well, in a way, but you took an oath to do certain things, and one is to enforce the law and the code says that that's your decision, not theirs. So.
And Doug and I have had this conversation in the past, not about your situation, but we had a situation where we were going to be concerned about the person coming in for the appeal was going to start arguing with Tammy and start causing a disturbance. And correct me if I'm wrong, Doug, anybody in the meeting, as far as the board, can say, you know what, this is getting out of hand. We need to stop. We're done. We're gonna stop the appeal, and we're going to read it at a different time or something. So anybody, if you feel it's getting out of hand, anybody, not anybody in the room, but any board member has the ability just to say, you know what, let's stop. Let's take a time out. Let's take a break. Let's stop. Let's back up. Let's reach out to Lynch Dallas. If it's a situation where Tammy or I are getting out of hand, let's get other personnel, whatever that may be. But just keep in mind that this is your meeting. You have the right at any point in time to say time out. Let's stop.
Yeah. And I would say if you ever do tell somebody to leave, be sure there's a record made as to why, just to avoid them causing a beef at some other later point. And I think a lot of times. Not all the time, but a lot of times it will be, maybe not even the appellant. It'll be likely somebody else that's getting out of hand that just needs to go. So, okay. This one, and I don't know if we'll be heard enough, this one is for your advice.
Thank you, Mayor. I'll try and keep this brief. I won't belabor all the details. I'm sure most of you remember.
That's the mayor walking away.
Presentation from last time, and I imagine he's going to hit some of the highlights here in a minute. But I do want to
to say that if your life has not already been touched by an antibiotic-resistant disease, it probably will be at some point. My mother has fought a MRSA infection. I have a high school friend whose 3-year-old son almost died from C. diff, and he will be dealing with the consequences of that for the rest of his life. But the thing is that these deadly infections, there's something we can do about it. And what we can do is call on governmental representatives that are higher up the chain of command.
The volume isn't great here, but the mayor has a mic, and the mayor went to the restroom.
Oh.
And
ask for action at the federal level. I am aware of Mr. Brainerd's concerns that he raised last time, and there would be instances where I actually agree that we should take action locally first, but there are not any KSL operations in Georgetown, so for us to just say within the city limits.
So, just, yeah. Picture the mayor walking back in now. You know?
So.
What's the funny guy?
Yeah. What did I miss? What did I miss?
Don't know any boundaries. So a state-by-state approach would just...
Right? I mean, how appropriate is that? Well, yeah. So, anyway, thank you. We can...
There'd be clusters of disease that would go across the border. Anyways, I'm going to stop talking now and ask that you give this serious consideration and approve this resolution.
Okay, so this last one's for code enforcement. Show some love. No. They deal, again, my experience in Clinton and working with them, they got to deal with some colorful people and some people who just aren't necessarily too into compliance, and truly, to show some love is a little bit in jest. They, from my experience, work many angles to try to get resolution before anything would ever go to court, before anything would ever come to you. Not just, not to say that things won't still come to you, because it will happen. Things will still go to court because people don't like to comply. A lot of times the failure to comply is money related, which is tough. That's always the tricky part. You've got a nuisance house, or you got a house with the roof caving in, but you got an 80-year-old lady on Social Security whose husband passed away 3 years ago, and she just doesn't have much money. What do you do? Those are the tough ones, and those are the ones I think code enforcement more than some of the others bend over backwards to work with. Then you've got other ones where people are either, maybe I'll use the term slumlords, or they buy property to use it and abuse it and walk away from it, or they buy it as a tax sale certificate, and they just want money. They don't really know what they're buying, and don't really care. And if it turns out too bad, they just want to walk away. So there's all different levels of participants in these proceedings, and we see a lot more. I haven't seen the case yet where it's the little old lady who just can't afford to fix her roof. It's always the other stuff, except for the cat lady. So, questions. For me, like I said going in, I didn't want to dig too hard into the specifics of the codes. I think you guys can look at those, and code enforcement knows those, of course. But when it comes to appeals before you, those, looking at the code is one of the things you'll need to look at and determine, is the action of code enforcement, is there something in the code that says they can do what they did? And if not, that's when they would lose their argument, if you will. But that's their job, to know what the code says and to enforce it, whether they like it, whether you like it, and go from there. So,
just a practical question, Doug. In looking through the code, there is a lot to look through. Is it possible that we could get copies of your slides?
Yeah.
Because they just targeted some things that I'm thinking, I remember seeing that, but it's amongst everything else, and I'm just asking the question.
Yeah, I'll send it to you, or Tammy, or both. They can shoot it out for sure. Then you can go back and watch those videos again. Okay.
This
Anything
was
else?
very helpful.
Good, I hope so.
Thank you, yeah.
Anything else you've run into where you've been troubled, during a hearing or during an appeal, or it's just like it's not real clear how to handle it, or you wish code enforcement would have done something just a little different, things of that nature?
Oh, I've had some, but you've addressed them already. I mean, we've kind of talked about them afterwards, but now you've addressed them.
Okay. Great. Okay.
Kind of say, I have friends say,
And what do you want to say for an inspection? Okay, the electrical outside, some of the wrappings was coming off, okay? And so to get the power shut off, you got to put all new boxes in. You know what I mean? So from a shrink wrap, say, to put on that pipe or that little bit of cord, and that, which, whatever, goes to $5,000.
Yeah.
I mean, is that in the code? And then the other thing that they did do is they sent the letter saying you're in violation of this. Well, I looked up that code and for the person, and it said pest control. You have a pest problem.
Okay.
And that has nothing to do with electrical.
Okay. So they cited the wrong code section?
Yes. Yeah. And the right way to do it would be to probably replace all them panels. But now the electrical company doesn't do that. You're the person's responsible for that.
Yeah. Yeah. I think if, in that case, obviously the wrong code section is one thing.
Right.
I mean, the letter probably explained what you need to do, but it cited the wrong code.
Right.
And, that's, in the electrical code, who inspects that for the city?
Well, that's kind of a hard question to answer without knowing what type of property it was. So we have Rich Johansson.
Mm-hmm.
He's our master electrician. He's the
Right. And
certified
he's good. Very good.
We have Eli Voss.
Okay.
Eli Voss was hired in July, and he is going through the ICC process now to get his certifications. He has more of an HVAC background, but he is working through that process, so he could have done the electrical inspection. If it was found during a rental inspection, it could have been Eli or myself.
If you have a situation where there's, I'll say a violation that's going to create a significant amount of expense because of it, if that violation, you make a determination if it's emergent, like really unsafe?
On the rental side, so on your situation on the rental side, if it was a rental inspection, and Eli or I went out, I can't speak for Eli, I went out, what I would tell them is I would say from the main electrical service line, from the weatherhead down into the service cable into the panel must be inspected. And what I tell the owners all the time is that if you get an electrical inspector to come out and they inspect it and they say, yes, it's deteriorated, it's in violation of code, but I think it's safe enough that we can do da-da-da-da-da, I'm fine with that. Because I've got a certified electrical, licensed electrician saying, here's my repair, boom. And that could be as put in conduit. Rich or Eli, under the building side, could go out and they could say, no, you have to completely replace it. Because when you look at the IRC, and the NEC, National Electrical Code, and those electrical codes, it gives the inspector the ability and the power to say, you must replace it. And it's spelled out in the code. So under rental, it's more open to repair instead of replace.
Under the building code, is it, because again, the expense, is it something that they could say, you've got to do it, however,
it would depend.
We're going to give you some time,
because
it's not emergent, like immediately dangerous. If you do these temporary things, we're going to give you 3-6 months to
I've got properties right now on a 1 year. They come to me, I got a gentleman, 400 block of 4th Avenue North. I go out, the weatherization from the weatherhead down is completely gone, pretty much in a section. It's about this much of a section. He has an electrical company go out, the electrical company looks at it and says, oh, this is dangerous. But we can do this to make it safe until we can replace it. It's not a permanent fix, but it's a temporary fix. And it was actually to wrap it in code-approved material until the repair could be made.
Okay.
So he provided me with that. It's $3,000 to fix. He says, I'm not going to have the money right away. He goes, it's going to take me a little bit. I said, well, how much time do you need? He said, I can probably get it done within the next year. I said, okay, I'll see you in a year.
Yeah.
Because, boom.
Yeah.
So a lot of it depends on the state of the wiring. Is it dangerous to the point that we can't give them time? And what is required under the repair? What people don't understand is some things are regulated by a line of energy. Even if I go out and I say, hey, yeah, you can put it in conduit, but to put it in conduit, they got to shut the power off. Alliant may come out and Alliant may say, no, we're not going to engage the power until you do. We want to shut off there. We want this. We want that.
Yep.
So some of it's driven by Alliant.
Yep.
So to save the client money, we enforce what Alliant is enforcing, because we don't want them to spend $3,000 to replace something, have Alliant come out and say, now you got to spend $2 more to do boom.
Yeah.
So I don't
Makes
think that
sense.
makes sense. But a lot of it is communicating back to us. Now, if it was a rental, what happened was when we went to Municity, which is a new computer system, and they brought over all the new codes, that transfer screwed up and it did not align the boxes right. So what would happen is I'd go out and I would look at smoke detectors, but it would put the code in there for windows in a bedroom. So we've actually had to go in, once that was identified, working with Municity, now that's all fixed, and that shouldn't be that way anymore if it's under the rental side. If it's under the building side, without seeing the letter, I don't know what was used for that.
And I could also see where it happens, and I get guilty of it too, and you start using a form letter, and you change everything except you forget to change that piece, you know what I mean?
Right.
Or forget to change the date, or that happens.
And code does state a clerical error does not invalidate the observation. So if I go out and do an inspection and I say, hey, you got to repair the weatherhead, you got to replace the service line, or have it inspected. Because what I normally, 99.9% of the time, what I say is got to be repaired or replaced. That's what my report says. Another inspector's report may be different, but when I say it, it's repaired or replaced. And I quote the wrong section, that doesn't invalidate what I observed.
Okay.
I make mistakes. But, yeah, I've got properties, like I said, a year.
No, that answered my
I have
question.
electricians that come out. I have one right now, and I can give you this information because I don't think it ever come to you. 500 North 4th Street. I went out under a rental inspection. I failed it. I said it immediately has to be repaired. Rich Johansson went out, says it has to be immediately repaired. The owner hired an electrician to come out. It's a multi-unit apartment building. The electrician came out, put the new meter boxes up, and it's been a year and 2 months now with new meter boxes, and they had to wrap the line. They did a bunch of stuff to the line to temporarily. They cannot buy the breakers to put them in the panels because they can't get the breakers anywhere.
Yeah.
So it's been a year and a half, a year and 2 months, and now we're being told it might be another year before it can be done. So that property is occupied. We're allowing it to be occupied because the owner, working with the electrician, made it safe, and the repairs are trying to be done, and it's out of their control. So,
Okay.
yeah, it's been, it would have been November of 2020. I put an immediate order on it, and American Electric went out, and they provided Rich Johansson with order spec from 3 or 4 different electrical order companies, and they're all saying 6 months to a year to obtain the breakers.
We always bend over. I mean, if a property owner calls us, we're always, I mean, Rich and I, Lori, we always go out, we'll meet with them. We meet with them here at the office, work with them. A lot of them, when you get with the property maintenance codes, the dangerous buildings and stuff, I've even sat down because they just don't know how to do a plan of action, and I've typed it up. We've sat and worked item by item and typed it up, and then they've signed the plan of action, and we're always willing to work with them. And even, and especially with since COVID, we're finding they just can't get the supplies. There's still that issue, and so as long as the big thing is we always tell them, just call us. Hey, you're not gonna meet your deadline of whatever to get fixed because you can't get that item, just call us. Show us that it's on back order, and we just put the notes in the system. You know, we'd rather give them the more time, have them repair. The last thing we wanna do is cause anybody any more heartache, money, anything. We wanna work with them. We want them here, happy residents, and we want them in a good, safe home. So, I mean, that's our ultimate goal, is always to work with them. It's the ones that ignore the letters or just basically just ignore us altogether that they end up in court because they just didn't.
Or they don't want to do it.
Yeah,
Yes.
just blatantly ignore us and just, or thumb their nose up and say, you know what, whatever, you know. Our ultimate goal is to always sit and work with them. If it takes them a year to get it done, if it takes them 2 years to get it done, we don't want to displace anybody, not even the cat lady.
And I tell them, if they can provide my office with a report from a qualified professional stating that the concern I have has been investigated and it is safe, then I'll give them the time they need to make the repairs as long as it's a reasonable amount. The case, I'll give you an example of the case I'm working on now. There is a enclosed back porch where there's a 7-inch drop from the center of the room porch to the corner floor. There's a 7-inch drop down on both sides. And I'm like, this is dangerous. We need to get this inspected. You need to provide me a report stating that it's structurally sound and give me a plan of action of repair. So the owner hired a contractor. Well, actually, I had a contractor go out. The contractor gave me a report stating this is caused by this, this, and this. My action of repair is this, this, and this, and this. I've added some secondary supports. I've done this, in my professional opinion. This porch is safe and will be safe as we make the repairs over the next 6 months. I can't make any repairs till spring because I gotta have thawed out ground. I presented that to my building guy. I always have a second eye. He looks at it. He says, looks good to me. I got a hold of the owner and I'll say, I'll see you in October. And I actually gave him till October. Because I've got something that now covers the city. I've got a licensed contractor who's provided me a report saying, I've done this, it's safe, we went out and verified it, and so now I've got something, so unfortunately, heaven forbid, that porch collapses. Somebody says, well, the city wasn't doing their job, I can say, here's what I got. And so a lot of it is I don't want to see, is eliminating liability on that property owner. On an electrical service on a rental, if the code says if that wire is deteriorated where I can see through it, that is a violation. Once I notify the owner of that, then that owner takes on that liability to make that repair. If they don't make that repair and the place burns down, the owner is liable. So by me pushing that and making sure it's safe, it helps that remove that liability also. And that's how I explain it to them. And once I explain it to them that way, then, oh, okay, yeah, and then we're good.
We always try to explain, and if they call and even need the code explained, I mean, we'll print it off. If they call and say, hey, I don't quite understand this code, we'll print it off, we'll meet with them, we help them. You know, cat lady, we helped her get into a place, we sat with rapid rehousing, helped her get into another apartment, so she was away from her residence and stuff. I mean, we always go above and beyond to help. I mean, we've even given contractors names out to say, hey, call them. I've had people call and say, I know I need my roof done, but the contractor isn't moving on it. You know, sometimes a phone call from us saying, hey, they really need to get this. Can you get up there and somehow bump them up or get them some help so they can get the project done so we're off their back. And so that always helps too. Sometimes a call to the contractor from us, especially when it comes to demos. We've had a few of them that were going to demo them themselves, and we've called the contractor, nudging them to say, hey, come on, we've got to get this going. We've got to get it done. So we're always willing to go above and beyond to help them.
Chase around utility companies that are cooperative.
Any other questions?
That also means, I would say, if you get somebody who calls you, don't be afraid to call us.
Yeah. Even ask them, have you talked to the person who sent you the letter? Because
Yeah.
Yeah.
That makes sense.
Yeah. Oh, okay, you know what? I will call Rich or Tammy or whoever and set up a time. I have no problem with you coming down with somebody and sitting down and talking and going over stuff. Just be cautious that if it ever leads to appeal, keep in mind now you're not part of that.
I go over there.
Yep.
If it was me, that I understand.
Ready for lunch break?
Thank you, Doug.
Yeah, thanks everybody. It was nice to meet all of you.
Thank you for giving up your time on a Saturday.
Yeah.
Thanks.
I was complaining to Lisa, yesterday was my birthday and I couldn't even go out or anything because I had to get up so early today.
It was your birthday yesterday?
Yeah.
And we didn't know that, Lisa?
I don't want to share everything with you in advance.
You could have harassed him
In
yesterday?
advance.
You got donuts for me.
I know.
You could have put a donut and a candle in it. And
Yeah.
The fire marshal would have came and shut the meeting down for an open flyer. And
No. So I live up by Manchester, so it's a pretty good drive. But then,
Just remember, having another birthday is better than the alternative.
I know it. Yep. And I've got a high school friend in DeWitt I'm going to stop and see on the way home.
oh,
And my mom and sister live in Macoka, so I can stop and they can take
Good.
me out for lunch on my birthday.
well, there's a couple really good restaurants
Decker
to
House
do it.
up there in the coconut.
What's that?
Decker House in the coconut.
Yeah,
Yeah,
it's
that's
back open again.
Very nice, yeah.
I grew up in Macoka, so it was
Oh.
open and closed constantly. So yeah.
Living in Jackson County, that explains a lot about it.
I know. I haven't lived there for years.
Okay, so that was our question and answer session. Does anyone else have any questions for Doug? Any other answers? I move to adjourn. Do we need a motion to adjourn?
So moved.
Yeah. All in favor?
Aye.
Aye.